Right out of the gate, this is a first appearance hearing. Basically, the court's first check-in after an arrest. No trial yet, no verdict, just three things. What you're charged with, whether there's probable cause, and whether you're getting a lawyer or walking into danger alone. Spoiler alert, this one goes off the rails fast.
Mr. Randall Pittman, good morning. Mr. Pittman, you've been accused of one count of, the first appearance sheet says intent or threat to do violence. I'm assuming it's an assault allegation once I read the complaint. That's the assault statute they're using. So you've been accused of one count of misdemeanor assault. And I've been advised through a text this morning, a text to Mr. Mitchell and myself from Mr. McDaniel, that you do not want an attorney appointed to represent you for first appearance.
And this is already a red flag. Defendants almost never refuse a lawyer at first appearance. This is the moment judges usually insist on legal help, because anything you say here can shape your entire case. So when a judge sounds shocked, that's not drama, that's experience talking.
Purposes. Is that correct?
That's correct, Your Honor.
Okay. So I don't know if I've ever had that at first appearance. Do I have to go through the same analysis for first appearance purposes as I would for representation?
Judge, I don't think I've ever seen that either.
But I think it is each stage of the proceeding that you have to inform him of his pro se rights.
Okay. So you have the right to an attorney. That's the best thing to do, especially if you don't have any legal background or legal training. But if you want to represent yourself, you're going to have to let me talk. That's one thing attorneys do, is they let the judge talk, and then you'll get a chance. We take turns. That's kind of how it goes. So I've got to ask you some questions to see if, about your educational background and your desire to represent yourself. And I've got to stress to you the importance of why that may be a bad idea. So tell me about your educational background, Mr. Pittman.
I went to Cottondale High School.
Okay. Any college?
Initially, and then I got transferred over to Graceville High School.
Any college?
I have a bachelor's degree. My brother and I received scholarships at Marshall University, football scholarships.
Okay.
I played
Mr.
football.
Pittman, what is your bachelor's degree in some kind of legal studies or something totally different?
My degree is in business administration.
Okay.
And
Mr. Pittman, did you have any postgraduate work? Did you work towards a master's or anything?
Well, I've been working undercover for the state of California for about 20 years as an attorney general.
Did you catch that? He just claimed he's been working undercover as an attorney general for 20 years with zero law school. Judges hear a lot of things, but claims like this instantly kill credibility. And once credibility is gone, every word after that lands differently.
Mr. Pittman, as an attorney general?
That's a sad point for Jackson County because they didn't know that. But I had to reveal that now because I'm in court.
Mr. Pittman, have you ever been to law school?
I've been going up and up. I'm sorry.
Have you ever been to law school?
I'm sorry.
I need you to listen to my questions, Mr. Pittman. I'm asking you specific questions for a specific reason. Have you ever been to law school?
No, I've never been to law school.
Okay. So here's what you got to understand. Mr. McDaniel has been to law school, an accredited law school. He's graduated from that law school. And then after that, he took and passed the Florida bar. And after that, he's been practicing law, Mr. McDaniel, in excess of 20 years. Is that right?
Correct.
So here's the thing. This is what I heard a judge explain it to me one time. He explained it to a defendant, and I was in the courtroom. You're about to enter a process, and the way the judge described it, you're about to have surgery. And what you're saying is that even though there's a surgeon here next to me who's willing to do the surgery, and that's his job, I don't want to do that. I want to go ahead and do surgery on myself. That's essentially the analogy that I'm using.
This surgery analogy is one judges use when they're genuinely worried. Representing yourself isn't confidence. It's risk. The law is procedural, technical, and unforgiving. And the irony, the more confident someone sounds here, the deeper the hole usually gets.
For you representing yourself. In other words, it's a bad idea. Knowing that, you still want to waive your right to an attorney and represent yourself for first appearance purposes.
Your Honor, I promise you, I'm the best attorney in the nation. I promise you that. So
do you want to represent yourself for first appearance purposes?
Yes, I do. Yes, I do.
All right. So do you want to be heard on the issue of probable cause?
Yes, I do.
Go ahead, please.
First of all, Your Honor, this was really a bad decision by the sheriff's department. Enfield, he's the one who he tells these guys to do this every time to me and my mom. He's already told me, I don't care where you take your mom, but you need to get her out of Jackson County. So that's why all this stuff keeps happening. It's called Enfield. And honestly, Judge Garcia, she's a good and fair judge, but she is being controlled by Enfield. That's why all this stuff is going on.
Your Honor, we're going to.
All right. So, Mr. Pittman, that's nothing to do with probable cause. That's just you rambling. So I'm not.
This is where things really matter legally. The judge shuts him down because probable cause isn't about feelings or conspiracies. It's about whether the alleged threat was imminent. Conditional threats often fail under assault statutes, and that technical distinction just became the turning point of this entire hearing.
Don't listen to any more of that. Mr. Pittman, before you elected not to use him, Mr. McDaniel sent a text this morning to Mr. Mitchell and myself questioning whether there was probable cause in your case. And his question was that it appears to be a conditional threat, and conditional threats typically cannot qualify as assault because the assault statute says the threat must be imminent. That's the key word in this particular analysis. Mr. Mitchell, any position on, or Mr. Gill, either one of you, on whether or not this meets the basis for probable cause for assault?
Judge, it does appear to be a conditional type of analysis. We would ask for 24 hours to amend. There could be facts that were not put in the probable cause affidavit to establish a charge for assault.
Okay, thank you, Mr. Gill. So the complaint says that you allegedly went to where those two people were at, and that may be considered an overt act, which may have a basis or a part of the analysis to determine whether or not there's assault or another crime. So what I'm going to do is I'm going to determine there's no probable cause for assault. But based upon your criminal history, as well as the recent mental health history that the record reflects,
I have no criminal history,
in the other case,
I have zero criminal history. I have zero criminal history.
You do have criminal history. You've been arrested within the last few months for a case involving your mother, correct?
They were all dropped. All those charges have been dropped. Did you not hear?
Fair enough. Fair enough. They were dismissed. You were arrested, but not dismissed. They're still part of your history. They're just not convictions. I'm going to hold you for 24 hours. I'm going to see you tomorrow morning. If they haven't amended the complaint to include probable cause, then I have to release you. That's the law. It's very clear. If they have amended the complaint, then what's going to happen is I will see if the amended complaint includes probable cause for a crime. If it does, I'll set you an appropriate bond or consider other release options. So I will see you in the morning.
You're not going to give me a bond today?
You're not getting a bond today because there's no probable cause for a crime. Now, if you want to waive the argument of no probable cause, since you're representing yourself, and agree that there's probable cause or stipulate that you're not contesting that, then I can set you a bond today. Otherwise, I can't set you a bond.
Yes, I'll do that. I need a bond today.
So you want to stipulate only for first appearance purposes that there's. Okay, you want to stipulate for first appearance purposes. Well, your mom's going to be in jail, and you're going to have to contact with your mom. I'm fixing to do a no contact order once I find probable cause based upon the history.
You got to be kidding me!
Absolutely going to do no contact. That is absolutely going to happen. You're going to have no contact with your mother because I think you're a danger to her. So my question for you is: do you want to waive any objection to probable cause so that I can set you a bond, or you want me to see you tomorrow and see if they can establish probable cause?
Yes, I want the bond.
Okay, Mr. Gill, you'd like to be heard on the bond.
Judge, we'd just be asking for a reasonable bond, and we would be asking for no contact with Willie Ruth Pittman.
Your bond's $5,000 cash or surety with a condition of no contact with your mother. To me, that is an absolute no.
And here's the final twist. Even with no probable cause for assault, the court still imposes a bond and a no contact order. That tells you this case isn't just about a charge. It's about perceived risk. So let me ask you, did refusing a lawyer help him, or did it quietly cost him everything?
Necessity to ensure her well-being. You have the right to use the phone and post the bond, sir. If you post the bond, you'll be released. Any questions, Mr. Pittman? Court date. January 5th court date. If you give him that notice, please, that would be at 9 a.m. You'll get his phone in just a few minutes, sir, okay? Have a good day. Mr. McDaniel, anything else from the public defender's office?
Nothing else, Your Honor. We appreciate it.
Mr. Gill, Mr. Mitchell. All right, ladies and gentlemen, it's 8:54. We're through with first appearance.